Hey everybody, Derek Judd, the Cowboy Criminologist, here with Cowboy Criminology. So last week was enormous for the channel. I was looking and we had 35% growth in viewership on the channel, which is absolutely fantastic. The watch hours shot up. This month alone is responsible for over 1,500, almost 1,500 hours worth of viewership. And if you're kind of following the growth of my channel, that's pretty good. So, you know what? Thank you very much for taking the time to look at my channel and for taking the time to really watch the video. Some of y'all are doing deep dives of my deep dives and pointing out things that I didn't really think about, or things that I had missed. One of the things was Sarah Boone messing with her fingers before the crime scene tech came in, the forensics tech came in and did the fingernail scraping. That was good. That was if you don't know to look for it, or you happen to blink or turn away or move your head, you really do miss it. But several of y'all have posted in the I think Ladybug did a good job. She posted exactly where you can see that, and a couple of others of y'all did too. So when I do these analysis, y'all, I'm not perfect and I do make mistakes and I can't catch everything. And sometimes I get so focused on what I'm trying to say or what I'm looking for that I do get my facts mixed up. I do get things kind of messed up. But I want to throw a special shout out to Dealey. Dealey commented in response to kind of defending the behavior panel about their take on it was that the detectives were continually talking over Sarah and not letting her answer questions. And I noticed that, y'all, that's just kind of a universal evil. It's not really, doesn't really pertain to law enforcement conducting interrogations. In regard, this is almost going to be a cell phone here, you know, being a content creator. We have this idea that in our society that because we have these social media platforms where we have a voice, we have a following, we have something, we feel like our opinion is the only one that matters. And it was funny, I was walking through the grocery store today, and it used to be that people would like move their carts to the side, or if there was a large group, they'd walk single file to make room for other people to get by. And those are just common courtesies from a bygone era. And when I was checking out, the cashier asked me a question, and as I tried to answer it, she completely cut me off, and I never got to finish my question. And so it's almost like, okay, well, you know, I didn't know if she really needed to know an answer to that question, if she was just making small talk, or I don't know. But anyway, be that as it may. So I don't think that's anything. I think that's just kind of a symptom that exists right now in society. We've kind of gotten away from realizing that other people may have things to contribute. And Dealey, you're absolutely right. In an interrogation, the most important thing that detectives can do is listen. A lot of good information was getting lost, and I think less so towards the second part of the video because, like I said, the interview started to circle. It wasn't getting any better for Sarah. It was actually just getting harder and harder to watch. But you could tell that the detectives started to get fed up. And matter of fact, you could actually, if you run the video back, you could probably timestamp exactly where each detective just said, you know what, I'm done. I'm done. And then Mr. GST360, he caught me on something. I missed this, and I got my facts wrong. And I don't mind. This is an open dialogue channel, and I will message back with everybody. I tried to do a good job getting to my comments and doing thoughtful responses, especially when y'all take the time to leave really, really good commentary. But Mr. GST, you're absolutely right. So when I talked about George being trapped in the suitcase, I suggested that he might have come down with carbon monoxide poisoning. Well, that's only something that happens from an exposure to a chemical, all right, like a gas leak or something like that, that would cause, or what else would cause that? Anything that would leak carbon monoxide, like people who will try to use certain grills or charcoal grills inside, that puts off carbon monoxide, which is why you don't do that in an enclosed area. And so that would account for somebody turning red. But I watched the video back, and Sarah actually asked why he was purple, not red. Okay. And so this leads me to believe that I was off on my cause of death. And so knowing what I know now, I think he probably had asphyxiated because of positional asphyxia, being locked in there. A couple of times, the suitcases has been moved. And so I think just being in that cramped position, and it really doesn't take a whole lot to induce positional asphyxia. As a correctional officer, as a police officer, paramedics, firefighters are all warned to look out for positional asphyxia, because even some of the most mundane positions, if you leave somebody there long enough, you can cause that to happen. So, Mr. GSD, you were absolutely right. That was a good catch on your part. And y'all, I'm not a proud person. So when I make a mistake, I own it, because I think it's a lot easier to listen to somebody who can own their mistakes and learn from them than it is to sit there and listen to somebody say, well, I wasn't really wrong because what you're failing to, and then they give you some long rambling explanation, and it just makes you realize that maybe they're not as good at what they're doing as they like to think they are. And so, you know what, Mr. GSD, good catch. You were absolutely right. You caught it, and good job. And that just shows how much attention y'all are paying to these cases, and good on you. So now, Cool Brader did an expert level troll, and I don't know if Cool Brader did this on purpose or by accident, but I'm going to read you what Cool Brader sent me in the comments section. I like your videos because of your law experience. Your analysis of how Boone was questioned was thoughtful. By the way, will you be volunteering to be her new lawyer? That works on so many different levels, because on one hand, Cool Brader almost seems to be implying that I will be through law school before this case ever goes to court. And on the other hand, I think I've pretty much shot myself in the foot doing an analysis of this of the Sarah Boone case, just because it is so, man, it is just so difficult to watch. Just when you're ready to throw her a bone and say, okay, maybe this could be what happened, and maybe this whole thing has an innocent explanation, and then she doesn't make it 2 sentences later, and she says something else, and you just facepalm, and you're just like, all right, and now I'm back to just having nothing for you. So while we're on the subject of having nothing for Sarah Boone, She had her first pro se court appearance. Pro se meaning, of course, meaning she's representing herself and not being appointed counsel. Now, all of this, of course, comes on the heels of her firing her last 8 attorneys. And in the last video, she had made a poster. She's trying to recruit an attorney. It does not appear that any attorney that is licensed to practice in Florida is really keen on this idea. I think even the public defender's office is just kind of sitting there going, "We tried." So now she's kind of flapping in the wind. Okay. And I'd gone back and forth about whether I wanted to play the full 18 plus minutes of the hearing, but I think after watching it, I think there's a lot of good stuff that we can actually. I think in defense of Sarah Boone, she does raise a couple of questions that I think, if they're not addressed properly before the trial, could end up being the basis for her appeal. Okay. And y'all, please understand. All right. I'm very much on the side of law and order. All right. I don't mind. I do want to see people held accountable for their actions. That being said, I do believe that everybody's still entitled to a defense, and I do believe that prosecutors sometimes overcharge, especially with the evidence that they have. Okay. Now, as I mentioned in the last video, Sarah Boone is the true crime gift that just keeps on giving. This is now my 4th video about her, and I will be completely surprised if it's not if I don't do another one. Okay. But she does raise a couple of interesting questions, and I had mentioned in her 58-page manifesto about her demands towards the court, she had raised some good questions. And I think when I was working for the Texas prison system, they have inmates called writ writers, WRIT writers. And writ writers will help other offenders with their legal cases. And these are usually inmates that have a higher level of education or a higher level understanding of the legal system. Now, I don't think Sarah Boone is a writ writer herself, and I don't think that she necessarily has somebody inside the jail system helping her. But what I do suspect is that from her knowledge in the criminal justice system, she's learned enough legal terminology and she's learned how to apply enough legal terminology to be able to create a document like that 58-page manifesto and be able to throw it against the wall and know that, yeah, everything that she's looking for is not going to land. But there may be 1, 2, 3 things that hit the wall and stick, and there's not really going to be any way to get around that. And she brings up a couple points in this video, so I'm gonna go ahead and be quiet. We're gonna go ahead and start the video, and we're just gonna take a look at Sarah Boone's first pro se court appearance. All right, here we go.
Mr. Cacciatore?
Dave Cacciatore on behalf of the state.
Ms. Boone, good morning. Could you please raise your right hand so Madam Clerk can swear you in?
I swear or affirm that the testimony you should give shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Ma'am, good morning. Could you state your name and date of birth for the record for me?
Sarah Boone, 10-10-77.
We also have a representative from Prison Break Investigations. Sir, if you could come forward, please.
Prison break investigations, I like that.
If you could, sir, raise your right hand. Madam Clerk's going to go ahead and swear you in.
Do you swear or affirm that the testimony you should give shall be the truth, the whole truth, and nothing but the truth, so help you God?
All right, sir, good morning. Could you state your name for the record?
Billy Lane.
And Mr. Lane, what's your affiliation with Prison Break Investigations?
I'm the owner and chief investigator for Prison Break.
Okay, very good. The reason the court had this hearing this morning is the court has found that Ms. Boone has forfeited her right to counsel and waived her right to counsel alternatively by virtue of her conduct in this case. As such, Ms. Boone is currently representing herself. The court has been working diligently to provide you the discovery. I received your letter, ma'am, and I have reviewed it. We have not forgotten about you. It's just taken some time in order to coordinate the appropriate processes with the jail. In conversations with the jail, a laptop has been secured and will be issued to you after USB drives are provided with all the discovery. Upon the jail's receipt of those items, the following provisions will be adhered to. The laptop, charging cable, and USB devices will be kept in the FDC main control room when not in use. At no time will the charging cord be placed in the housing unit. Upon the return of the laptop to the FDC main control, the laptop will be placed on the charging cable to ensure it is available for the next day's usage. The laptop and USB device is to be accounted for with the control room inventory. The control room DST or CO will make logbook entries for the issuing and returning the USB device and laptop. The dorm officer will make logbook entries for the receiving and returning of these items to the applicable movement officer. A notebook entry will be completed in IMS for every issuance of the laptop and USB device to inmate Boone. The laptop and USB device will be available daily to you, Ms. Boone, between 0800 and 1600 hours. A notebook entry will be completed in IMS for every issuance of the laptop and USB device to yourself, Ms. Boone. The discovery was provided at the court previously and is in the two banker's boxes that are in front of the court to your left, Mr. Lane. I'm going to order you, sir, to take possession and custody of that discovery that was provided to the court previously on June 28, 2024. You, through Prison Break Investigations, shall copy all of the discovery onto as many USB jump drives as necessary. The Judicial Administration Commission for the State of Florida shall be responsible for the fees and costs due to Prison Break Investigations for copying all of the discovery onto as many USB jump drives as necessary. You will appear for a hearing with the court on August 1st, 2024 at 8:45 in courtroom 12A of the Orange County Courthouse with the discovery and all USB jump drives containing the discovery. A representative from the Orange County Jail shall also appear for that hearing as well. At that point in time, Prison Break Investigations shall hand deliver all USB jump drives containing the discovery to the representative from the Orange County Jail in order to be placed onto the laptop that is currently secured and to be issued to the defendant for all trial and court preparation. Do you have any questions for me, sir?
I have a conflict for August 1st, Your Honor. I'm
Okay.
supposed to be out of state from Tuesday until Friday of next week, which I believe would encompass August 1st for my son's wedding.
Okay, well, congratulations. When do you return from your son's wedding, sir?
I will be back late Friday evening, so I'll be available the following week.
Okay, will you be able to complete that task by that time?
Yes, sir, I'll do my best.
Okay, sir, we will see you on give me a second, I want to make sure I get the date right. Monday, August 5 at 8:45.
Yes, sir.
Okay, you'll be given a copy of the order that I just read from. Ms. Boone, you'll also be given a copy of the order. Do you have any questions for me?
I am thoroughly confused. Was a notice ever put online for this or mailed to anyone? I don't even know why Mr. Lane is here. I don't know why I'm here.
Well, ma'am, you are now representing yourself, and previously you had requested to appear at every hearing that was held. As you are now representing yourself, the court cannot have any hearings regarding your case without you being here. I put on the record and explained to you the process that the court has had with communications with the jail. I'm not allowed to look at any of that. I'm not allowed to copy any of that. So in speaking with the jail and understanding that you still have a private investigator that was provided to you through the state that's being compensated by the state, You're still allowed to utilize his services. The protections of the attorney-client privilege are still applicable to him, so he's able to review any of these documents, ensure that they are safely copied without violating any terms of the privileges. Those will then be placed on multiple USB drives and provided to you. Those USB drives will then be uploaded to a computer that has been secured for you at the jail for you to access all of that information.
Okay. My question is, was a notice of hearing posted or mailed to anyone to where apparently the news crews obviously got it? How is it that I do not know anything about this other than my bunk being kicked at 3 o'clock in the morning telling me I have court?
Ma'am, I have no other way to get in touch with you other than setting the hearing, which was set yesterday once I received confirmation from the jail.
All right, stop it there at 21:45. Okay, so looking at that, so the judge is absolutely right. You know, he's not supposed to look at any of that evidence because obviously he's the judge. He has to weigh that evidence in case the case is ever taken away from the jury, and he has to be able to make an unbiased decision about it. So the other thing is with Sarah Boone representing herself, she obviously has to be at every court hearing. There's no way around that. But she does ask a very good question there. How is it she just found out at 3 o'clock in the morning that she had to be there, and the news media found out about it and was already in place for this hearing? Now, obviously, the judge doesn't know anything about that. He just sets the hearing, but that can be easily explained. Generally, the media will contact the clerk's office and ask them about upcoming hearings and things like that. But what Sarah appears to be doing right now is trying to raise a question of bias or some sense of impropriety, not necessarily on the part of the judge, but she's definitely kind of throwing some shade there. And she has very limited knowledge of what's going on. And in a case like this, I think the judge really needs to be careful about, while everything he might be doing might be consistent with what you'd call black letter law, like the absolute letter of the law, he's got to be careful to make sure that he is communicating with her to the best of his ability, and that might mean giving a little more latitude. So a lot of this is going to come to time. I was making some notes here. The discovery was given to the court on June 28th. Okay. And we're now July 30th. And of course, this was just from like 5 days ago. So there seems to be a 3-week lag time there. And to top it off now, the investigator who is supposed to be working alongside Sarah Boone and helping her out is going to be delaying that another week. And so, you know, she's going to have about 3 weeks to review all of her evidence. Okay. And that's pretty much where we stand right here. So is that going to be enough of a legal issue for an appeal or anything like that? I don't know. Maybe not, but let's get a little further. All right, so we'll pick it up back here at 2518.
For how this would work. And I understand that your case is important, and I want to move it as efficiently, as diligently as possible. I know that you've been waiting for this information, and it took some time to confirm the process with the jail. You've advised me that you have very limited space, you have almost no privacy, you have a small drawer where you can keep some personal effects. We could not send all of those boxes with you to the jail, and the jail advised me that they cannot take all those boxes. A process had to be created to make sure And this is the process.
The process that I was explained after speaking to a couple of sergeants, and I've been waiting for that, and I would much rather prefer a hard copy of these to where I can write on them as opposed to anything that's on a laptop.
I am unable to provide that for you. I have been provided the process has been provided to me by the Orange County Jail.
Okay, I'm stuck there at 2622. So that right there, that seems to be an issue that could be solved with allowing her to have a legal pad. Now, they are giving her between 8 a.m. and 4 p.m. to review those documents. And after that, she has to turn everything back in. She can't take any of that stuff back to her cell, obviously for security issues. A legal pad would seem to be a good compromise for that, where she could sit there, take notes, and kind of ruminate on stuff. And they can't just give an inmate unrestricted access to their legal materials. It's a security issue. It's, I promise you, she's not the only inmate in Florida right now who's trying to get ready for a case, okay? She may be one of the few who have drawn this much national attention, but anyway, that being said, she's still looking for, she wants the hard copies, which I can totally understand. And this is where she might need to become a more diligent note taker. And depending on what the institution's policy on writing materials and how much writing material an inmate can have, that could be a concern as well. But that's another good question. Is she able to, remember, she's her own attorney now. Is she getting what she has to mount a sufficient defense? That's going to be the question. All right. So we'll pick it back up here at 2825.
I understand that's your preference, but I can't do anything more than what I've done right now.
I understand. And I have had other information given to me, which is why I've been waiting for the boxes for them. So
Yep. Sergeants don't make policy, so that's irrelevant.
pursue continuously still for me to be able to receive my hard copies, because no one tells me anything.
I cannot answer that question because that may call for me providing you legal advice, which I am prohibited from doing.
Okay. Well, because I have no other way of contacting you other than in a letter, and it's AKA worldwide. So am I supposed to go back and speak to the captain and whoever else it is that I might need to speak to in order to receive these?
Again, I cannot answer that question. All I can tell you is that we will have a hearing on August 5, whereby which Prison Break Investigations will provide all of the information on USB drives. Those will be provided to a representative from the Orange County Jail, who will place all that information on a laptop for you to use, and that's accessible for your use from 0800 to 1600.
So that's 19 days from the time she gets her information to the time her trial starts.
I guess I will figure that out, because if I'm up at 2 o'clock in the morning, I can't utilize the laptop, which is another reason why I was looking forward to the hard copies. So my other question is my time prorated for the time that I've been waiting for my discovery?
I'm not sure I understand what that means.
Will I be having...
Okay, we'll stop there at 2948. Okay, so that was actually one of the more cogent questions that we've heard her ask. Is my time going to be prorated? Now keep in mind, the prosecution turned this stuff in a month ago. All right. It's going to take till August 5th for her to get all that information, and that only leaves her 19 days to mount a defense in a murder trial. Okay. That question right there, like I said, from my legal knowledge, but just based on what I'm seeing, that right there could be the basis of her appeal. Because if the prosecution has had all of this time to prepare their case, because they've had the evidence, they've been able to go through it and be able to review it, and now they're giving it to her. Now they're giving it to her. She's not an attorney, so is she going to know if there's any exculpatory evidence that exonerates her? Is she going to know if anything has been left out? Is she going to? She doesn't know what to look for. Now, part of that falls under the category of her problem because of her behavior up to this point. Unfortunately, that could potentially come back and bite the court, because if the judge is not willing to grant her sufficient time to review that evidence for whatever she may find, to raise whatever defense that she's planning on raising, now we do potentially have an issue. Now, obviously, like I've said, I'm getting ready to train to be a lawyer. I'm not a lawyer yet, and I'm in Texas, not in Florida. So there are some things that may apply jurisdictionally that would be a big deal in Texas, maybe not a big deal in Florida, but Texas and Florida usually are fairly complementary on their laws. So I think we're safe in making an assumption, but that right there seems to be the big thing that could turn this whole thing sideways. So we're going to pick it up here at 3233.
Or will it be extended from the time period of me waiting for my discovery still?
I'm not in a position to answer. I don't know what it is that you're asking for.
My pretrial is supposedly set for September 24th, I believe it is. So obviously I will not be prepared, and obviously I do not know what I'm doing, and obviously I'm still waiting for my discovery. So for that time period that I have been waiting for almost 4 weeks now, will that be added to the time frame in order for me to be properly prepared?
As of right now, the dates are what the dates are, ma'am.
Okay, so I just miss a week, a month.
The dates are what the dates are.
So I also sent you, I believe, 5 motions. Have you received those?
No, ma'am, I have not.
They were mailed last week.
Then I have not received them yet. The last correspondence I got from you, ma'am, was received on July 8th.
Okay. 5 motions I've mailed. They're probably sitting wherever else it is, considering it takes a day for you all to receive my mail, considering I'm right down the street from you all. So I have those also in order, which may change whatever information or whatever, anything that I...
All right, stop there, 3338. All right, and right there, she does such a good job raising a potential legal argument, and any sympathy, it just disappears 2 sentences later, because she's almost implying that people are deliberately slowing down the delivery of her mail and everything. Well, Congress can't even control the U.S. Postal Service, so I don't know what Jedi mind trick she thinks the judge can pull. But that right there, those little insinuations, those are not helpful to her. And I don't know why she hasn't figured out, well, I mean, if she was as smart as she thought she was, she wouldn't be in the situation that she's in. But those little digs and those little quips really takes away any reason anybody has for wanting to help her. All right, so we're going to pick it up here at 3451.
Fire in between now the month less that I have in order to prepare for my trial. That's in October. So if you could keep an eye out for those also. I don't know who I'm supposed to ask. How did Mr. Lane come into any of this? Like, how was he called?
Mr. Lane has been your investigator in this case, and he was advised to attend this morning's hearing by virtue of being provided the discovery in order to digitize it so that you can have access to it.
The court contacted him?
I did not contact him.
Am I allowed to speak to him directly?
You can?
Mr. Lane, who contacted you in order for you to be here, please?
The JA contacted me.
If I'm pro se and my own attorney, shouldn't I be included in all of this so I know what's going on and not a surprise hearing like it is again for the second time?
Ma'am, again, this is why there were
Fair question.
benefits to being represented by counsel. The court has already identified in its 16-page order the reasons for why you no longer have those benefits.
Right, which
It
is
makes things
malformed.
exceptionally more difficult, as I explained to you, in communicating with the court and communicating with the state attorney's office.
Isn't that what a certificate of service is for anything that's filed by anybody in the court?
There
That
was,
should be included in that.
ma'am, there was no certificate of service for setting this for today. This was coordinated by the JA. You were advised as soon as it was set yesterday.
It's just very odd to me that the news knew about it before I did.
Again, I can't speak to that.
And so nonetheless, my constitutional right to counsel is being forfeited on your behalf in the court. So now I don't get appropriate notice in preparation for me to be able to be here and doing what I'm supposed to be doing and act as and perform as?
I've already addressed the reasons, ma'am, for why there was a forfeiture and alternatively a waiver in the 16-page order that you were provided. Again, it's difficult to communicate with you based on where your current housing is. I'm not able to pick up the phone. The judicial assistant's not able to pick up the phone to communicate with you or send you an email to schedule certain things. And it leaves a little bit of a level of further complication.
How is it the news knows before I do?
You keep asking the same question, and the answer is going to be the same. I cannot answer that question for you because I do not know.
Okay, but you do know it's harder for me.
I would agree with that, yes.
And you do know that you did not ask me any questions in regards to your order. You just read it straight off and never asked me what's what or how many with anything of it.
Ma'am, if you have questions, I can certainly try to answer them. I'm trying to facilitate you getting that information that you're certainly entitled to, and it took time for a process to be created by the Orange County Jail, as they had advised me. They do not have a place to store 2 banker's boxes of information, nor are they in a position to provide you physical copies. This is what I've been advised as the process is. As soon as that process was finalized, I set the hearing. This was finalized yesterday.
No one ever asks me. I've been waiting for the boxes. I really don't know what to say, and because I supposedly have no way to contact you other than a letter, and the same for you, I don't know how the news crews got here before I did, but I don't know going forward, how is it that I'm supposed to be able to communicate with you other than me sitting here in front of you at these, I guess, supposed surprise hearings that I'm going to have every single time that it is that you would like to speak to me? Is that what it's going to be?
Ma'am, I cannot answer that question. All I can tell you is that you can communicate with the court through the avenues that you've been utilizing previously, by and through letter writing. As I said, I do not have your letters that you sent last week. They're not in the court file, and they were not in my inbox yesterday. So as soon as I receive them, I will diligently review them, and if we have to set a hearing, you'll be properly noticed for it.
In the certificate of service?
You'll be properly noticed for it, yes, ma'am.
And will there be a proper notice for today?
Notice was performed last night. I've already explained.
Am I allowed to ask the news crews how they got here?
No, ma'am, I'm not going to let you do that. They're not under oath. They're not a party to this action right now.
It's wrong and it's unfair.
You're certainly entitled to that opinion.
Am I allowed to ask him a question?
Sure, go ahead.
Mr. Lane, how is it that you and I are supposed to be speaking to one another?
So,
It's a good question.
it would be, since you're now the pro se, that either you or your honor gives me access to the jail to visit with you, and I will be happy to do that. It is the policy of the Orange County Jail to have a letter from an attorney to allow me to access you. That's the reason for the past previous attorneys have not had the ability to come out and access you, but that's changed. And I will be happy to continue to move forward with any investigative actions I can do for your defense, as long as I get that access.
So you need a letter from me.
Or the judge, or the jail, somebody that will allow me access to you. Yes, ma'am.
And I send it to you directly?
Yes, ma'am.
Is this a letter also that you'll be supplying to him?
I don't know that I'm in a position to compel the Orange County Jail to do anything.
But you all are the ones who contacted him.
But I can't tell the jail, let this person come talk to you. If they have a policy where you need to provide the letter, then you need to provide the letter.
So until you have that letter, you and I will not be able to speak with one another?
I will contact you myself and find out if there's an extension for pro se, or maybe they can speak to you directly to circumvent the actual letter itself.
Ma'am, do you have any other questions?
I don't think you have enough time. I'm just doing my best, and if you could please keep an eye out for my motions.
I will be on the lookout for them. You said there were 5, correct?
Yes.
I will be on.
Please include me on the certificate of service for whatever hearings that we have that are no longer a surprise for me, please.
Understood. You'll be given a copy of the court's order that I read.
Okay, so we'll stop it right there at 4130. Yeah, she does a good job raising a question, and that's something that's really important. Is if a judge already recognizes that something is an issue, and you keep browbeating it, it's going to become less of an issue. But she has raised a couple of good points. You know, the delay in getting the discovery. Is she going to have extra time? Now, an independent investigator has been assigned to her case who's supposed to help her, but now she has to go through all these extra steps in order to be able to contact this individual. And what are the policies for the jail for a pro se defendant meeting with a private investigator on their case? You know, a lawyer has substantially more latitude, but are they required by law to afford that same opportunity? So anyway, these are the type of things that I think can potentially lead to Sarah Boone's appeal. You know, it's as far as a criminal procedure case, if you were looking for a case to study and really kind of learn what criminal procedure looks like, this would be a good one, because there's so much nuance to this, with everything over the last 4 years just getting to this point. All right, so we're gonna switch gears and we're gonna move on. So League City, we had talked about. I did a video 2 or 3 weeks back asking if there is a serial killer in League City, Texas. And of course, this comes off of a woman being found suspended from the dock in the marina, who was already dead. So it was a staged crime scene. And I did a video before that, and we looked at the news clip, and we listened to a 5-6 minute interview with the boyfriend. And you notice I left it pretty much, I was 50-50. Like, if the cops had taken him in, I totally would have gotten it. And if the cops would have eliminated him as a suspect and moved on, I would have gotten it too. But there was a lot of behavior there that I said was very difficult for me to overlook. One of the things was there are very few truths in crime scene staging. And one of those truths is that criminals do not stage crime scenes. Only somebody close to the victim will stage a crime scene. And there are potential reasons for that are nothing sinister. The death could have been an accident, and the way the person died, friend, family member, loved one, whoever, doesn't want the individual to be embarrassed, shamed, ridiculed for how they died. Autoerotic deaths are a very, very common way in which crime scenes are staged. The loved one will come in, they'll find their loved one non-responsive in a state of undress. Maybe they're dressed in gender opposite clothing, one thing or another like that. And so to prevent embarrassment to the deceased, they will alter the crime scene. All right. It's not to throw off the police. It's not to anybody trying to avoid any kind of criminal culpability or anything. It's a fairly innocent response, even though it in itself does constitute a crime. All right. There's nothing sinister behind the motivation for it, is what I'm trying to say. Now, with the other type of crime scene staging, it is a little more sinister because somebody has died and now you're trying to make it look like a completely different crime. A lot of times you'll see this scenario play out in a stage burglary where the victim is in a state of undress, like maybe the female victim's shirt is lifted up or her pants and underwear are pulled down, but there's no sign of sexual assault. There's usually not really much sign of a burglary or any kind of confrontation either. And that's usually a dead giveaway that the crime scene is staged. And once again, it goes back to somebody close to the victim. One of the other things that I noticed is he kept referring to her as that girl. I love that girl. We love that girl. That girl was my life. Never, ever said her name. Never said Giselle's name. And that right there is very telling, that distancing language. Creating that barrier between what is known about how personal the relationship is. Now, I want to show you the video that was released to the. I want to show you the video that the news put out on it. Now, keep in mind, we'll watch the video and then we'll talk about it. So let's watch the video in its entirety first.
It is a story that got a lot of attention earlier this summer. A woman's body found hanging on a League City boat dock.
Yeah, at the time, her boyfriend was desperate for justice. Now he's charged in relation to the case. Jason Miles in League City with the latest tonight.
League City police tell me this is still an active investigation and that further charges are possible in what is a very strange case. It's been nearly 2 months since a disturbing discovery in the Wharf Marina. A woman's body found dangling from a dock the morning after her boyfriend claimed she'd left their boat.
This is the worst thing that's ever happened to me. It feels like a nightmare you can't wake up from.
51-year-old James Hart told us in an interview that 30-year-old Giselle Salazar-Tapia was the love of his life and that the mother of 4 went to the bathroom in the middle of the night but never came back.
I want justice for Giselle.
Yesterday, Hart was arrested at the marina in connection to his girlfriend's death.
Mr. Hart, James Hart.
This is video from his Galveston County Magistrate Court appearance. He's charged with tampering/fabricating physical evidence with intent to impair a human corpse.
You understand the charge that is before you?
Not really, but I understand what she just read to me.
From the beginning, League City Police suspected foul play in the case and that Hart is the only suspect. In a statement today, a spokesperson told me, quote, LCPD detectives are hoping to have the Galveston County Medical Examiner's Office's full report to include Salazar-Tapia's toxicology report sometime next week. So at the moment, this is still an ongoing investigation.
What I do know is I didn't have anything to do with it, and I never would have. I love Giselle.
An investigation centered around this once seemingly concerned boyfriend. Hart's bond was set at $80,000. Among his bond conditions, he must stay in Galveston County and can have no contact with Salazar-Tapia's family. Reporting from League City, Jason Miles, KHOU 11 News.
We will see what happens next in this investigation. Jason, thank you.
So So $80,000 bond is not, he's not charged with murder. Okay. And they read the charges, basically tampering, altering, attempting to conceal. This is actually really good police work and really good on the prosecutors, because if the toxicology comes back or any other forensics that don't show murder, so toxicology, high level of alcohol, drugs, what have you, something fatal, something that can explain that this was a pattern of personal behavior that elicited the death and wasn't the intended action of somebody else, okay, is probably the best way to look at that. They can still hold him accountable for moving the body. Now, how did he end up moving the body? How did that whole thing come to be? We don't know. There has to be some kind of evidence. Now, obviously, somebody commented that there are cameras all over that place, and they couldn't believe that nothing had been found out yet, which tends to kind of contradict what we knew about Clark from previous videos, where he said that he wasn't even a person of interest, he's been cooperating. Well, part of the arrest warrant that was issued for him that I saw on a different news channel said that they were able to recover deleted text messages, and that Clark's mother was notified 3 hours before Giselle's body was found. And so that kind of blows the whole thing. He didn't know she was missing. He didn't know what had happened to her. He was just as concerned as everybody else. And so you start putting these things together. I think it's just possible that he thought he was a little more clever than he was, and that by deleting certain things, he was able to conceal whatever involvement he had, whether that was moving the body, staging the crime scene, or what have you. All of those things can be proven. You can make these logical inferences. Okay, delete the text messages. Those text messages do not go away. And unless you have significant knowledge of media programming, like cell phones, computers, things like that, those things are very difficult to get rid of. So somehow they were able to tie him to the staging part of this whole thing. But they stopped short of charging him with murder. But this is also very common. Charged with a lesser element that you can prove, and then you can keep your suspect in jail while they're trying to make bond, while you're waiting on getting information back that kind of fill in the gaps of your case. So something interesting. Clark said something in one of the interviews we saw, how he wasn't even the one who found the body. And I thought that was kind of an interesting thing to say, because I've mentioned in other videos, giving too much detail raises questions. There's an axiom, especially in criminal profiling, that the first person to find a body is generally the killer. And there have been times where that has absolutely been the case, and there's been times where that's, just been absolute garbage. I did a video a couple months back about the woman who was found in the storage tote in Arkansas, and she had been decapitated. Horrible crime scene. But it was two teenage boys out riding bikes or something that found her. So did they have anything to do with it? I mean, the first one's there. No. So you got to be really careful about that. That's why it's always so important to go back and to look at what people have said in context of what your evidence shows. Okay? Remember, you're not always looking to use what they say to prosecute them or try to make the evidence line up, but you're trying to understand how the evidence and how what these people are telling you do line up. And sometimes something can be very easily explained. There was a case where a guy and his girlfriend had gotten into a fight at a bar, restaurant, something like that. And she walked out, left the boyfriend at the bar. The boyfriend leaves, goes a completely different direction. But the girlfriend was found murdered. And when the cops were questioning the boyfriend, he kept saying, "It was all my fault. I killed her. It was all my fault. I killed her." That was a guilt response, because what he was saying is because he wasn't with her, because he didn't go after her. He wasn't there to protect her, and that's how she ended up dead. And so he took that as being on him. And so you've got to be really careful about understanding why people are saying what they're saying. And this case, I was always, I straddled the fence, but I always kind of leaned on the side that he had something to do with it. At the very minimum, he had something to do with the crime scene staging, because that's just, like I said, it's a universal truth. And so it'll be interesting to find out what happens later. Are they going to be able to connect him to the murder of Giselle or the other victim? Because remember, there was a victim that was killed 2 weeks after Giselle was, in the same arena. So something to look forward to. And one thing I forgot to mention, going back to Sarah Boone, if y'all will permit me, one of y'all mentioned, or a couple of y'all have mentioned, an intoxication defense. Here's the thing. Sarah Boone had the potential to have several different defenses, and she's managed to shoot every single one of them down, either based on her actions, based on her words, and based on her inability to cooperate. You know, in her mind, she was seeing it as not getting herself in any deeper, when in all actuality, that's all she was doing. And so we had talked about the battered woman defense in the last video, and I said it's going to be really hard to raise that, considering at no time in the interview, in the initial contact with the body-worn camera, of course I didn't see the first interview, so I can't say with 100% certainty, but in the body cam, which is the first video I did, and the second and third videos that I did on her with the second interrogation, nowhere did she ever say that she's afraid of George. Now, she said that she admitted that they fought, but she never said that she was afraid of him. She's afraid of George's family. She never said she was afraid of George. At least to the best of my recollection, I don't ever remember her. You know, she was scared about what was happening to her, and she was afraid about what, this grand conspiracy that had been concocted against her. But I don't ever recall her saying that she was afraid of George. Okay. So I was looking into what is needed to raise a specific defense. And some of you have correctly pointed out, mixing drugs that fall into the benzodiazepam family and alcohol is always a colossal no-no. All right. It can cause a lot of different things up to and including memory loss. There's just one problem. throughout this entire interrogation, she has been very, very explicit about how much alcohol she has consumed. And I don't remember anywhere in the body cam video where she mentions needing... No, I guess she did mention that she needed medication for anxiety. I'm pretty sure that's correct. And then nowhere during the interrogation did she mention anything until she mentions the last time she was arrested that she had a panic attack. Okay. So, but she also made it very, very clear neither one of them were under the influence of drugs or alcohol. She was very adamant about how much they had to drink. They each had to drink. Very, very specific about the amount, the time frame, the whole 9 yards. So I looked up an intoxication defense, and I found this. In order for a defense to be available, a defendant must be able to show that as a result of intoxication, they did not understand the nature of their actions or were incapable of understanding the difference between right and wrong. So the problem is she admits she knew George was in the briefcase, in the suitcase. She admits they were having a good time. And everything that happened after that was completely unintentional. So by her own words, her own actions, it's going to be very hard to raise either of those as a defense. So I don't know where she's going to be able to go with any of these things. And I don't know if any of the judge's decisions or rulings up to this point are going to be egregious enough that they, one, convince an appellate court to retry the case or vacate the sentence altogether, because I have no doubt she's going to be convicted. But she did raise some points. Now, obviously, it's going to take better legal minds than mine to really figure out all the nuances to it. But at this point, as good as that defense would sound, that intoxication defense, not remembering what she did, you have to remember her own testimony has been how with it, how together. Remember, she doesn't like being non-compos mentis. So if that's true, she would avoid drugs and alcohol together. The other problem is, as many of you have pointed out, she is no stranger to alcohol, and alcohol seems to be a pretty prominent fixture in her life. So what is her tolerance for mixing medications? Because let's face it, if people consume one drug, there's a good chance they consume another drug, something that enhances the effect of the other. Okay, so just something to think about. So these two cases, Sarah Boone and the Giselle Salazar-Tapia case, have really taken kind of interesting turns, and it's going to be interesting to see how these cases develop. Excuse me. I would be willing to bet that once the Sarah Boone case is decided, and providing nothing else hinky happens, and at this point, if this case managed to find its way to the Supreme Court of the United States, I wouldn't be shocked. As a matter of fact, I'd be more shocked if she gets sentenced, she goes to prison, and nothing else ever happens with the case. That would shock me. But I think the Sarah Boone case is one that's probably going to be studied for a very long time, not just by criminologists, penologists, law students, but true crime enthusiasts. I think it's just going to be one of those things that it defies so much social convention, and it's just it's just taken such a daytime soap opera turn that now everybody's invested, and shame on y'all for getting me addicted to this case, because now every time I see something new about it, I gotta look into it. I gotta look into it. Y'all, thank you so much for supporting Cowboy Criminology. Please continue to like, subscribe, and share on your favorite social media platforms. Y'all helping build up the channel over the last 6 months. It's been phenomenal. I want to thank each and every one of you. Thank you for every view, every like, every comment, every subscription. Y'all, it means so much to me, and I hope to keep it going and keep delivering content that y'all are going to enjoy. I'm Derek Judd for Cowboy Criminology. I am the Cowboy Criminologist, and I will talk to you later.